Breaking news out of Washington tonight. The United States Supreme Court has taken the extraordinary step of intervening in an emergency case that directly targets firearm permit requirements. And now, the Department of Justice has officially stepped in to support the challenge. This is not routine. This is not normal. And if this case goes where many legal experts believe it's headed, it could permanently reshape gun laws across the entire country. Right now, millions of Americans are required to ask the government for permission before they can purchase or carry a firearm. That permission often comes with high fees, long delays, mandatory training, and discretionary approvals that vary wildly depending on where you live. And the speed at which this is unfolding is what has constitutional scholars, court watchers, and state governments on edge. Emergency cases at the Supreme Court are almost always denied. The court receives thousands of emergency petitions every year, and the vast majority never even make it to full consideration. For the justices to step in, especially on an issue as politically charged as firearms, signals that something very serious is happening behind the scenes. Even more telling is the Department of Justice's involvement. The DOJ does not lightly involve itself in Supreme Court emergency matters, particularly when the federal government is not directly enforcing the law being challenged. Their decision to support this case sends a clear message. The legal foundation of firearm permit requirements may be far weaker than states want to admit. So what exactly is this case about, and why did it trigger an emergency response from the highest court in the land? At its core, this case challenges whether states can require permits for the exercise of a constitutional right. The plaintiffs argue that firearm permits, whether for purchase or carry, function as a prior restraint on the Second Amendment. In other words, they force citizens to obtain government approval before exercising a right that the Constitution already guarantees. This argument isn't new, but the legal landscape has changed dramatically in the last few years. In Bruin, the Supreme Court made it clear that gun regulations must be consistent with the nation's historical tradition of firearm regulation. If a law did not exist at the time the Second Amendment was ratified, or if there is no historical analog, then it is presumptively unconstitutional. That decision was supposed to settle the issue. But instead of complying, many states openly resisted. Some states kept their existing permit systems intact. Others expanded them. New fees were added, new training requirements were imposed, new discretionary standards were quietly baked into the process. In some cases, states rewrote their laws in ways that were clearly designed to preserve control while technically claiming compliance with Bruin. Lower courts, especially in certain circuits, went along with it. Judges began interpreting Bruin as narrowly as possible. Historical evidence was dismissed, analogies were stretched beyond recognition, and in many cases, courts simply upheld permit schemes by relabeling them as administrative rather than restrictive. This growing defiance is one of the main reasons this emergency case exists. According to legal analysts following the case, the plaintiffs argued that lower courts were deliberately slow-walking or outright ignoring Supreme Court precedent. They claimed that waiting years for a normal appeal would result in ongoing constitutional harm to millions of people who are still being denied their rights every single day. The Supreme Court appears to have agreed, at least enough to step in. What makes this moment even more significant is the timeline. From the moment the emergency petition was filed to the court's decision to intervene, only a matter of weeks passed. In Supreme Court terms, that is lightning fast. Typical constitutional cases take months just to be scheduled and often more than a year before a decision is issued. Here, the court moved with urgency. Sources familiar with the process say that justices were particularly concerned with evidence showing that permit systems are being used as tools of delay and denial rather than neutral background checks. Applicants waiting months or even over a year for approval, applications rejected without explanation, processing halted entirely during emergencies, and all of this happening while crime rates fluctuate and citizens remain unable to legally defend themselves. The DOJ's backing adds enormous weight to these concerns. In its filing, the Department of Justice reportedly emphasized the constitutional principle that rights cannot be conditioned on discretionary government approval. While the DOJ did not explicitly endorse nationwide constitutional carry, its position signals that permit systems, as currently structured, may not survive serious constitutional scrutiny under the Bruin framework. That alone should send shockwaves through state legislatures, because if the Supreme Court rules that permit requirements violate the Second Amendment, the impact will not be limited to one state or one law. It would set a precedent that applies nationwide. And that's exactly why this case is being watched so closely. Permit requirements exist in multiple forms across the country. Some states require permits just to purchase a handgun. Others require permits to carry, even for law-abiding citizens with clean records. Many require both. Fees range from modest to exorbitant. Training requirements range from basic safety courses to multi-day programs that require time off work and hundreds of dollars out of pocket. Supporters argue these systems promote safety. Critics argue they function as modern-day poll taxes on a constitutional right. This emergency case forces the Supreme Court to answer a question it has avoided for decades. Can the government charge citizens money, impose delays, and demand approval before allowing them to exercise a fundamental right? The fact that the court is addressing this question now, on an emergency basis, suggests that the answer may finally be coming. And if history is any guide, when the Supreme Court steps in this aggressively, it's usually because the justices believe the lower courts have failed to follow the Constitution. This is only the beginning. How many Americans are impacted right now, and why this case could immediately change life for millions of people across the country? To understand why this Supreme Court emergency case has state governments scrambling, you first have to understand how many people are actually affected by firearm permit requirements, and how these systems function in the real world, not just on paper. Right now, tens of millions of Americans live under some form of firearm permit regime. In certain states, you need a permit simply to purchase a handgun. In others, you can buy a firearm but must obtain a separate permit to carry it, even for self-defense. Some states require both. And in nearly all cases, these permits are not automatic. Applicants must submit paperwork, pay fees, complete training, undergo background checks, wait for approval, and hope the issuing authority decides in their favor. What's often left out of the public discussion is how unevenly these systems are enforced. In theory, permit laws are supposed to apply equally to everyone. In practice, approval timelines, costs, and outcomes vary dramatically depending on geography, local officials, and even political climate. Two people with identical backgrounds can have completely different experiences depending on the county or even the individual official processing the application. This is one of the central arguments being raised in the emergency case now before the Supreme Court. Plaintiffs argue that a constitutional right cannot depend on administrative discretion. A right that can be delayed indefinitely, priced out of reach, or denied without explanation, they say, is not a right at all. And there is no shortage of real-world examples. In some jurisdictions, applicants report waiting 3 to 6 months for a decision. Others wait nearly a year. Some are denied with no clear reason given beyond vague language about subjective concerns. Appeals can take even longer, often requiring legal representation that many people cannot afford. Fees are another major barrier. While some states charge relatively modest amounts, others impose cumulative costs that can exceed several $100s once application fees, fingerprinting, training courses, and renewals are factored in. For working-class Americans, these costs are not trivial. Taking time off work from mandatory training alone can mean lost wages on top of direct expenses. Supporters of permit systems argue that these measures promote safety. Critics counter that safety should not require a paywall, and that rights enumerated in the Constitution were never intended to be conditional on income, location, or government approval. This tension is exactly what has drawn the Department of Justice into the case. According to court watchers, the DOJ's filing highlights concerns that modern permit regimes have drifted far beyond anything resembling historical firearm regulations. Under the Supreme Court's Bruin decision, the government must demonstrate that modern gun laws are consistent with the historical understanding of the Second Amendment. That is where permit systems run into serious trouble. Historical research submitted in recent cases shows that during the founding era, Americans were not required to obtain permits to own or carry firearms. While certain groups were unjustly disarmed at different points in history, there is little evidence of broad, neutral permit requirements imposed on the general population. This lack of historical precedent is a major vulnerability for states defending permit laws. It's also why many states are nervous right now. If the Supreme Court rules that permit requirements themselves are unconstitutional, the consequences would be immediate. State and local governments would be forced to halt enforcement. Ongoing prosecutions could be challenged. Existing convictions might come under scrutiny. Entire regulatory frameworks would need to be rewritten or abandoned altogether. But the implications don't stop there. Permit systems generate significant revenue for state and local governments. Application fees, renewals, training certifications, and administrative charges collectively bring in hundreds of millions of dollars nationwide each year. In some states, these funds are folded into general budgets rather than being strictly limited to processing costs. That creates a financial incentive to preserve the system. A Supreme Court ruling striking down permit requirements would eliminate that revenue stream overnight. And for states already facing budget pressures, that prospect alone is enough to trigger alarm. Beyond money, there is also control. Permit systems give governments leverage. They allow officials to decide who may exercise a right, when, and under what conditions. Even when approvals are common, the mere existence of a permit requirement acts as a deterrent. Some people never apply because the process is too expensive, too time-consuming, or too uncertain. Legal analysts argue that this chilling effect is not incidental, it is central to the system's design. And that argument appears to be resonating with at least some members of the Supreme Court. The emergency nature of this case suggests the justices are concerned about ongoing harm. Every day that permit laws remain in effect, plaintiffs argue, citizens are being denied or delayed in exercising a constitutional right. From the court's perspective, allowing that harm to continue unchecked while a normal appeal drags on for years may be unacceptable. That concern is amplified by what has happened since Bruin. Instead of uniform compliance, the country has seen a patchwork response. Some states moved quickly to align their laws with the ruling. Others openly resisted. Still others complied in name only, crafting new rules that preserved much of the old system under different labels. Lower courts added to the confusion. In some circuits, judges rigorously applied Bruin's historical test. In others, courts upheld gun regulations using broad interpretations of historical analogs that critics say stretch credibility. This inconsistency is another reason the Supreme Court may feel compelled to act now. When constitutional rights mean one thing in one state and something else across a state line, the court often steps in to restore uniformity. That is especially true when lower courts appear divided or defiant. The DOJ's support strengthens the case for intervention. While the department is not arguing that all gun regulations are unconstitutional, its position underscores a key principle. Constitutional rights cannot be treated as privileges granted at the government's discretion. That principle has implications far beyond firearms. If the court rules that permits are unconstitutional because they function as prior restraints, similar arguments could apply to other rights. That makes this case one of the most closely watched constitutional battles in years. And we are still only halfway through the story. In the final part, we'll examine what happens next, how a Supreme Court ruling could trigger a nationwide domino effect, and why legal experts believe this decision could become a defining moment for the Second Amendment. Now we come to the most important question of all. What happens next if the Supreme Court rules in favor of the emergency challenge, and what would that mean for the rest of the country? According to constitutional scholars and Supreme Court observers, the effects would be immediate, widespread, and impossible for states to ignore. If the court determines that firearm permit requirements violate the Second Amendment under the Bruin historical framework, enforcement would likely be halted almost instantly in affected jurisdictions. State attorneys general would be forced to issue guidance. Local authorities would have to suspend permit processing. Courts would begin applying the ruling within days, not months. This is where the domino effect comes into play. Legal organizations on both sides of the gun rights debate are already preparing for what happens after the decision. Gun rights groups have assembled litigation teams ready to file challenges the moment a ruling is issued.
These lawsuits would not be speculative. They would rely directly on Supreme Court precedent, making them extremely difficult for lower courts to dismiss. Experts estimate that dozens of existing gun laws could become vulnerable overnight. Permit-to-purchase requirements would likely be the first to fall. Carry permits would follow closely behind, but the ripple effects wouldn't stop there. Waiting periods, mandatory training requirements tied to permits, licensing fees, registration schemes, and discretionary approval standards could all be challenged using the same constitutional reasoning. In short, the entire regulatory structure built around firearm permits could collapse. That is why state governments are watching this case with such intensity. For years, restrictive states have relied on permitting as the backbone of their gun control framework. Remove that foundation, and much of the rest becomes legally unstable. Without permits, enforcing related restrictions becomes far more difficult. The administrative leverage disappears. The ability to delay, deny, or discourage lawful ownership is sharply reduced. This is precisely what supporters of the challenge want, and what opponents fear. Some legal analysts have compared the potential impact of this case to other landmark Supreme Court decisions that fundamentally altered the legal landscape, not because it affects one policy, but because it clarifies a constitutional principle in a way that leaves little room for reinterpretation. If the court rules clearly and broadly, lower courts will have far less flexibility to reinterpret or sidestep the decision, as many critics argue they did after Bruin. That is reportedly a major concern among the justices themselves. Sources familiar with the court suggest that one reason this case moved so quickly is frustration. Frustration with states that ignored prior rulings, frustration with lower courts that applied constitutional tests selectively, and frustration with a legal environment where Supreme Court decisions are treated as suggestions rather than mandates. That frustration may translate into a ruling that is unusually direct. Instead of narrow language, the court could issue a sweeping opinion that explicitly states permit requirements are unconstitutional as a category. Such a decision would leave little ambiguity and little room for delay. The Department of Justice's involvement reinforces that possibility. By backing the challenge, the DOJ has effectively signaled that the federal government does not believe permit systems can be reconciled with the Constitution under the current legal standard. That position will carry weight not only in this case, but in every future challenge that follows. It also changes the political calculus. States defending permit laws would no longer be able to frame the issue as federal overreach versus state authority. Instead, they would be arguing against both Supreme Court precedent and the federal government's constitutional interpretation. That is a much weaker position to defend, legally and politically. For ordinary Americans, the effects would be tangible. People who previously faced months-long waits could legally purchase or carry firearms without bureaucratic delays. Fees that once added hundreds of dollars to the cost of exercising a right would disappear. The patchwork of state-specific permission systems would shrink dramatically, creating greater uniformity across state lines. Supporters argue this would restore the Second Amendment to its intended status as a right, not a privilege. Opponents argue it would reduce oversight and increase risk. That debate is not going away, but after this ruling, it would shift from courts to legislatures. States could still regulate firearms within constitutional limits, but the days of using permits as gatekeeping tools may be over. And that may be the most significant outcome of all. This case forces a long-delayed constitutional reckoning. For decades, permit systems have existed largely unchallenged at the highest level. Now, with a clear historical test in place and an emergency case on the docket, the Supreme Court appears ready to confront the issue directly. The timing matters. The court is currently structured in a way that favors textual and historical interpretation of the Constitution. Several justices have openly criticized lower courts for resisting that approach. Others have expressed concern about rights being eroded through administrative processes rather than outright bans. This case sits at the intersection of those concerns. If the court acts decisively, it could mark a new era in Second Amendment jurisprudence, one where the focus shifts away from balancing tests and toward historical consistency and constitutional clarity. And that would not only affect gun laws, it would send a message to states across the country. Supreme Court rulings are not optional, constitutional rights are not negotiable, and emergency intervention will be used when necessary to enforce compliance. That message alone could reshape how states approach not just firearms, but constitutional rights more broadly. We are now waiting on oral arguments and ultimately a decision that could arrive far sooner than most Supreme Court rulings. When it does, the impact will be felt immediately by courts, lawmakers, and millions of Americans who have waited years for clarity. One way or another, this case will be remembered. It may be remembered as the moment permit requirements ended nationwide, or it may be remembered as the case that forced states to fundamentally rethink how they regulate constitutional rights. Either way, the Supreme Court's emergency involvement and the DOJ's support ensures that the outcome will not be minor. This is a defining moment, and as soon as the court speaks, everything changes. That's the full picture of what's happening right now in this breaking Supreme Court emergency case targeting firearm permits. If you want to stay informed as this story develops, make sure you're following closely because the next update could come at any moment.